I'm gonna give it just a minute more, but as you guys are joining, if you want to introduce yourself in the chat and say what part of the state you work in and how long you've been a guardian, that would be great. I'll give it one more minute and we'll start at 3:03. Katina dropped in. She's in Orlando. She's been a guardian for 11 years. Robin's out in the Fifth Circuit, Marion, Citrus, and Lake County. We got people from all over today. Maria says she's out in Hernando County. She's been doing this for 25 years. That's a long time. Okay, it's 3:03. I'd like to take the pleasure to introduce our guest speaker today. Attorney Catherine Davey has been doing this for over 30 years, and she has a daughter with developmental needs, so she's passionate about what she does, and she walks this walk every single day. Catherine, thank you for coming here and speaking with us today. As Catherine gives her presentation, we're asking you guys to please put your questions in the chat. Just hold them, like as you're thinking of them, pop them in the chat, and at the end of the presentation, we'll go through the questions and have a question and answer kind of session, and we can talk through some of your questions. So as you think about them, just put them in the chat, and at the end of the presentation, we will get to all your questions. Okay, I'm going to go ahead and share your presentation, Catherine.
Awesome.
Okay, and it's all you.
Hey guys, I'm Catherine Davey. I'm a probate, guardianship, estate planning, and special needs attorney here in Central Florida. I'm from here, grew up here, and my office is in Maitland, but I practice pretty much all over the state. I am here today to talk to you about guardianship, guardian advocacy, and the alternatives. And what I always tell people is that before I had my youngest daughter who has Down syndrome, who you see over my shoulder in that photo, her name is May, like Mae West, and you will hear me talk about her quite a bit during the presentation, as well as my other kiddos. I always say I thought I had a really good handle on guardianship and the alternatives and how all this worked. And I'd been practicing more than 20 years, and I thought, gosh, I really got this. But it's amazing what a difference having, a personal interest and a vested interest in all this makes. So then all of a sudden you learn so much more from such a different perspective. And I've certainly learned a lot from my fellow parents and mentors and all those things. So, all right, so that's me. So let's learn about guardianship and the alternatives. So these are my three daughters. My oldest is 21, a senior in college. My middle on the right, I've just dropped off at FSU to start FSU next week as a freshman. And May is 10, and they're in the middle. So I include this photo of my girls because I talk about them and occasionally talk smack about them, but I promise you I've done all these things to them as well. And I talk about them in the conversation about this because different things I did applied to different daughters. So alternatives to guardianship, everybody walks in thinking they've got to do something, but there are all sorts of alternatives, and I make sure that every client understands the different options. Not everybody needs to walk into guardianship as the only choice there is. So there's supported or shared decision making now. There's substituted decision making, which is powers of attorney, healthcare surrogates. There's guardian advocacy, right? If we're talking about people with intellectual and developmental disabilities. And we're talking about regular old run-of-the-mill guardianship as well. So we'll also talk about next steps and what do parents or you as guardians need to know, and then some resources that might be helpful for you as well. So, all right, next slide. So the question becomes, why do parents have to do anything at all? And the reality is, as you know, and my older daughters have learned, because when each one of them turned 18, I always teased them that I would invite them to the office for lunch. And they realized that was actually code for you have to come sign your power of attorney, healthcare surrogate, and living will, and then mom takes you to lunch. So my older daughter, I fooled into, no, I didn't really fool her. She knew what was coming. With a mom who does this for a living, she knew what was coming at her. So, but the reality is, as a parent of a child who's turned 18, you no longer have the right to make medical decisions for them, financial decisions, or really any of those things. And so parents of children with special needs know and have been told a million times as their kiddos have grown up that that will be an issue as that, as they get closer to that age and then turn 18. So the parents are concerned they won't be able to make those decisions. They're concerned that somehow their kiddo will be exploited or taken advantage of in some way financially, that no one's going to allow them to help their child. They can no longer advocate or protect their child, and they can no longer advocate for them in school. So that's why. So now what are our options? Next slide, Miss Ma'am. All right. So some of the other things we can do before we even have to cross that line is, if you're concerned about financial abuse, we can freeze their credit, right? It may be that as parents, you guys froze your kids' credit once you got their social security number on the off chance somebody would take advantage of that. It could be your concern is that the doctors won't discuss their treatment or health issues with you anymore. If it's possible, if your kiddo can do it, they could sign a HIPAA release form. If you're concerned that there'd be no one to act on their behalf if you can't, I always remind parents not to forget about their own estate planning, right? I mean, we're also committed to and worried about our kiddos. We forget to put the oxygen mask on ourselves first and think about the options that are created through that. We're concerned about our kiddos' behaviors and being able to protect them. So I remind parents that in Orange County and lots of other counties across the state, there is a registry where you can have your kid identified as having special needs, may act out differently, may not respond typically. Frankly, I had stickers made that I give out to clients all the time that say, the occupant of this vehicle has special needs. They may not react typically. I say as well, I'm incredibly blessed that my child has Down syndrome because you can see her disability written all over her face. That's not true for other people and other disabilities, and becomes harder for them. So that's why that's so important. And that maybe educators won't continue to work with mom and dad. And so there are some FERPA releases that are being developed and are included in some of that supported decision making. So there are options, and I'm trying to give all the options as we work toward guardianship or guardian advocacy, but well before you have to get there. So, all right, Ms. Mann, there we go. All right, so I love the Florida Developmental Disabilities Council's visual for this, their triangle, their graphic, because it really helps you see in a really simple way, if least restrictive is supported decision making, all the way up to guardianship as the most restrictive. You see all the different options all the way along, so you understand kind of as you're crawling toward that highest, most restrictive option, and trying to avoid that where you can, right? It's not appropriate for everybody. So what other options are maybe a better choice for each individual family? All right. So supported decision making, I always describe it in this context, and that's why I use the slide for this. The first time you bought a car, you likely went with your parents, maybe your uncle or your aunt, or maybe there was a best friend or their parents. Like there was a tribe that went with you the first time you bought a car. Maybe still when you buy a car, I don't know. But that's supported decision making, right? Like your mom or dad checked over the engine, somebody else maybe looked over the paperwork, maybe somebody else was checking something else. There was a whole tribe that went with you to help and support you. And that, in its most basic essence, is what supported or shared decision making is. So if you can give me the next slide. So it's a tool that allows people with disabilities to retain their decision making capabilities, and they're called supporters, is the person they choose. So in the context of the classic durable power of attorney, it's still the principal and agent, but it's a person using supported decision making. It can be a written or an oral agreement. There's now a written agreement in the statute. There are also some on the ACL's website, and it allows the person to continue to retain that control without having to go into further or different types of, the other options I've laid out. Ms. Ma'am? So as I mentioned before, shared decision making was recently adopted under the power of attorney statute. I've given you that statute link so you've got it. And some of it, yeah, sorry, I can't see my own slide, just way the PowerPoint. Okay, so So, and just so you know too, they've also updated, if you don't, I don't know who you all work with regularly as your attorneys, but they have updated the FLISI forms and all those things to reflect those changes in supported decision making, and that it's been considered as an option before you move on to guardianship. So, yes, ma'am. Next slide. So, but I always want to remind people of the pluses and minuses of each thing that we're doing, whether it's guardianship or supported decision making. There's going to be strengths and weaknesses or potential problems with each decision or choice. So the because it's so new, people at agencies may not be familiar with the concept of supported decision making. What I tell every family is it works until it doesn't. And if it doesn't work, it could be at a catastrophic moment when all of a sudden it's not working, or the bank or asset holder or whoever is not accepting it. Also, as you all know from dealing with attorneys as much as you do, we're always concerned about fraud, undue influence, manipulation, coercion, or other forms of abuse. And frankly, the litigators I've talked to are concerned it could be a huge boon for litigation. So what I'm telling people when I present and talk to parents or others is proceed with caution. Like, this is an option, and it may be a great option for some people, but it's also a potential for disaster for others. So, okay, next slide. Okay, so, but if you want to learn more about this, or your clients or the people you're working with want to learn more, I wanted to make sure you have tons of good information to give them and to connect them to, and there it is. All right, so substituted decision making, you can go ahead and flip to the next slide. This is the stuff you've probably heard of many, many times, right? This is a power of attorney, a healthcare surrogate. These are those classic things. And when I first started talking to or speaking about these topics, people asked me whether a person with an intellectual or developmental disability could sign a power of attorney. And I was, I have to admit, pretty hesitant and not sure at all. The longer I've had a child with special needs, the more I'm like, well, tough to tell. At 10, I can't say she would, but at 18, maybe. So I wanted to make sure you guys had the statute handy to look at it, because the bar is actually pretty low. So at the bottom, it says, must a person be competent to sign a power of attorney? The answer is obviously yes, but here's all they have to have. The principal must understand the power of attorney document at the time it's signed, right? They have to understand what it is conceptually. They have to understand the effect of giving that power of attorney. So could May understand the power of attorney document was going to mean that I would continue, or that I would make decisions for her, who it's being given to, right? It's me, the mom, and what property would be affected. She might. Like, that's not impossible. She absolutely might be able to understand that. And that's not true, obviously, for everybody. But as I think of it in terms of my own kiddo, it's absolutely possible she may be able to do that when she turns 18. We'll see. Okay, next slide. Okay, classic healthcare surrogate. Certainly you guys know about this too. Same kind of gig. It's a legal document that names another person as the representative to make healthcare decisions if I can't, right? So in the event I can't make my own healthcare decisions, my best friend Jean's going to make decisions for me. And I have the right to choose or refuse medical treatment as long as I'm competent. Okay, next slide. And can a person with IDD sign advance directives in Florida? The law is very clear. It's under 393.12, which is the statute that covers all this. And absolutely, the answer is yes. And if, just like in guardianship, just like you're used to, if a person with IDD has IDD is intellectual or developmental disabilities. If a person with IDD has signed these, you can't go forward and do a guardianship or a guardian advocacy if they are valid and were validly executed and properly signed at the time they were executed. So if this, then nothing else, right? So, okay, next slide. All right, but just like with supported decision making, there are absolutely challenges to using substituted decision making. And the answer is, neither the power of attorney nor the healthcare surrogate gives the agent the right to make decisions against the will of the principal. So what I always say is, you can't force someone so my daughter May hates blood draws. So let's just say at 18, she signs a healthcare surrogate. Here you go, mom, here's your healthcare surrogate. In the event I can't make healthcare decisions, you can make them for me. Well, I've just told you she hates blood draws. Can I force her to have a blood draw after she turns 18 if I'm her healthcare surrogate? I can't. I can't. If she makes bad financial decisions, if she gives her money away, if she goes and plays the lotteries, or she, is addicted to gambling, can I stop her with the power of attorney? No, I can't. So I always remind people that it's not a trump card against people or against the will of the principal. It's just in the event they can't act themselves, right? So that's a pretty substantial, limitation on the value of this as an alternative to guardianship. Not that it's not one, but it could be a substantial limitation on why this would be helpful. Okay, next slide. All right, there's me and Judge Takis and a dear friend of mine and her daughter who has Down syndrome out in Lake County, the day we did a guardian advocacy for her daughter. Next slide. So guardian advocacy generally, right, as we continue up that triangle, under chapter 393.12, it's guardian advocacy is really a streamlined process that removes certain rights from people with intellectual or developmental disabilities. So if you're in a car accident, this is not the way to go. But if you were identified as with an intellectual disability or a developmental disability, it allows the court to take away certain rights and appoint a guardian advocate to make very specific decisions for that person. It has all the oversight and control of the court for the lifetime of the person, or until the rights that were removed are restored to that person. So, okay. So the basis of disability, like I just said, is it's got to be an intellectual or developmental disability as defined in the statute. Again, I've given you the statute. It can be limited or plenary. I say plenary-ish. I'll explain that now. The statute actually is very clear that only some, but not all, rights can be taken away in a guardian advocacy. So it could never really be plenary, but the reality is in most circuits, they're happy to take them all away, and they are not finicky about that. So oops, that's exciting. I don't know if you guys are seeing that.
Yeah, I am too. That is exciting. Suzanne, can you maybe stop drawing on the slides, please? And thank you. I'll see if I can get rid of it. Hold on, let me go back a little bit.
I'm like, either something's going on or I'm crazy, but
no, you're not. But go ahead, Catherine.
I'm going to keep going. You try to fix your thing. So just understand that could be an issue if a person with an intellectual or developmental disability wanted to, or if the family wanted to take all their rights away. It may not be, that may not be possible, but frankly, most of the time, and I practice all over the state, I've really never had it be an issue. So, all right, next slide. Okay, developmental disability is defined in the statute. We start with intellectual disability, and you're okay, Suzanne, but now we know how to spell part of my name, so you're good. So, okay, so intellectual disability, and then for reasons I don't really understand, we only list the following 6 developmental disabilities, right? I mean, if you know anything about developmental disabilities, there's dozens and dozens of them, not just 6. So I'm not sure why we only have these 6, but if I end up with someone like Angelman's or something else like that, then we just call it an intellectual disability and move on from there. But they are listed there: cerebral palsy, autism. The statute hasn't been updated to reflect autism spectrum disorder, but obviously it's everything. Down syndrome, Phelan-McDermott, Prader-Willi, and spina bifida. And it has to constitute a substantial handicap that can be reasonably expected to continue indefinitely. I say that specifically because, especially with spina bifida and even cerebral palsy, it can be they have a physical handicap, but it may not be a mental handicap at all. It depends. And honestly, that's true with Down syndrome. So honestly, I'm not sure why I'm making that distinction, because it's true for all of them. The joke in the world of Down syndrome is, if you've met one person with Down syndrome, you've met one person with Down syndrome. You should never broad brush the entire group with, oh, they can't, or none of them can, because that's not true. So, and that's true for every group. So, all right, next slide. Okay, so the next question that most parents are really thinking about and worried about is, am I going to have to hire an attorney for all this? And the answer is the guardian advocacy statutes were actually drafted so that parents could do this themselves. They do not have to be represented by an attorney, as long as their child or the person with IDD does not have property. If May has property, if she has an ABLE account, if she somehow inherited money from her grandparent or something, then yes, I would have to have an attorney ignore the fact I am one. Just I would have to have an attorney. And then, as you all know, the ward always gets an attorney. So that's sort of shocking and surprising to parents. But we always explain that to them, that it's just like on TV with people in criminal proceedings, that if you're going to take someone's rights away, they get to have an attorney during the process. So even more so than in regular guardianship, in cases like this, where we have a person with IDD and it's the parents normally that are trying to get guardian advocacy, it's I'm going to say usually not a dramatic or confrontational process. Occasionally it is, right? We have mom and dad fighting over a child or a loved one or something like that, or family members fighting over a loved one. But normally it's not a dramatic process. And the court appointed attorney through the Office of Regional Conflict Counsel, it's a very positive experience for everyone, and they try to keep it as positive as possible. So, all right, next slide. So we don't have to, so the difference is we don't have to have an examining committee. There's no examining committee of 3. Instead, it's just a letter from the person's treating physician. Just pretend it's May's regular pediatrician that says May has Down syndrome that manifested prior to the age of 18. She's unable to handle her affairs related to finances and physical well-being, and that she needs the assistance of a guardian advocate to meet the essential requirements for her health, physical health and safety. So what I did when we first started getting into this after May was born, and I started really doubling down, and I'm super involved in all sorts of things about this now, I created a form that's modeled after the annual treating physicians report, the physicians report you're used to seeing, because I figured judges would be used to seeing that, doctors might be used to seeing it as well. So it'd be fairly easy for us to help them through that document that would need to be provided to the court, so the court and the different attorneys involved would be comfortable seeing it. So there you go. Next slide, Bam. There we go. All right. But the statute is also broad enough that if you needed to provide other things, you're absolutely able to. It can be an IEP, it can be a family or individual support plan, it can be any reports they have related to the person's disability or other professional reports. Sometimes we've gone and gotten neuropsych evals, we've gotten all sorts of things. So it's fairly straightforward, and judges try to be very flexible as they work through this process, because occasionally, like after Hurricane Maria, there were all sorts of families that didn't have complex medical records, but they had enough to get through the process. And the judges are very kind about what they'll consider and review. And as long as it's obvious that this is what's in the best interest of the individual, it's all fine. So, okay, next slide. Okay, and you guys are already used to seeing this, but sometimes this is part of a presentation that I give to parents as well. So this is often quite new to them. So I break up delegable versus non-delegable rights. Marry, vote, driver's license, travel, seek or retain employment versus the one that can be delegated, that are frequently property rights, but we break them up this way. And in the next slide, I think, yep, then we distinguish person versus property, right? So we're trying to explain to parents and to anybody who might be involved in this process, whether it's IEP or transition coordinators or whatever, how the guardianship process works generally. I actually love these slides so much, I now use it in my regular guardianship presentations to clients as well. So, yep, sorry. Okay, so, oh my gosh. Sorry, so
Is everything okay?
Yes. So here's what's happened, you guys. This is the story of my life, and you guys know you pivot where you need to. So I dropped off my daughter at FSU. My daughter with Down syndrome had a complete breakdown that mom's not around. So we're halfway back to driving to Orlando, and I am, in a parking lot doing this presentation. It's not like I'm sitting in my office. And so I'm just trying to manage all the things like we all do all the time, trying to make sure that my daughter's not losing her ever-loving mind as we try to get home to make life easier. Because as you often know, dealing with people with all sorts of intellectual disabilities, whether it's Alzheimer's, dementia, or an intellectual or developmental disability, things don't quite sit the same way for them, and they struggle with some of that same reality. So although I promise you I'd prepped you for months and months and months, as had her older sister that we were off to college, it's been a real struggle for her. So trying to balance all those things. So, okay. So anyhow, rights retained in a guardian advocacy or in a guardianship, right? This is something else I remind clients all the time. Just because, mom's in a guardianship or whatever, these are the basic rights everybody gets to keep forever. I don't care what level of guardianship they're in. They get an annual review. They get to be restored to capacity at the earliest possible time. They get to be treated humanely with dignity and respect and protected against abuse, neglect, and exploitation, to have a qualified guardian or guardian advocate. So when mom and dad start to get precious with me that even though they've got a criminal background, they should still be able to do this, that, or whatever, or they've bankrupted the family 4 times, I have to explain to them they have to qualify to be a guardian, and the court may or may not perceive them to be qualified. So, to remain as independent as possible, to be properly educated. It is a huge thing in the special needs community that they get a free and appropriate education as they're entitled to under the federal law. Whether they do or not is a different problem, or is a problem we struggle with all the time. They're entitled to receive visitors and communicate with others. We can't just lock them off in a bedroom, which I actually had a client who was suggesting that perhaps her child should be in the basement behind a locked grate. Yeah, you just love it when people actually say those things out loud to you. To receive services and rehab necessary to maximize their quality of life, right? We're always hopeful about making life a better place. So I remind every client now, and honestly, I have them sign off on a form I've created that includes this language, because when they fuss with their siblings, this, that, or the other, no, they get to have, as long as it's safe and appropriate, and the ward, they get to have visitors, they get to do all these things. So anyhow, that's just my reminder for them and for all of us, right? Because it's easy to lose track in the heat of the moment. All right, next slide. So the rights typically removed in a guardian advocacy. So you guys know the laundry list of 12 or 13. We typically add the educational one, which isn't really a real right under the guardianship statute, but it's a common issue in guardian advocacy, because guardian advocacy, obviously they're turning 18 and they're entitled to stay in the public school system until they're 22. So that educational piece is something we've added in. But most often in I've said Orange County, but it's really kind of Orange, Seminole, Osceola, Lake. You're going to see this group of 5, sometimes more rights taken away. Those are the ones, not always the whole list of 13, because remember, if we do property, even if property requires they have an attorney. So if we can avoid it, we try to do that so that they don't have to continue to incur the cost of an attorney. Yep, I know it seems antithetical to me having a job and paying for that sweet little nugget who needs all the things she does. But parents of a child with special needs have taken on, just a huge amount of financial burden frequently. And I wouldn't change it for the world, but I understand why they want to avoid one more expense. And if I can teach them how to do their annual plan, and if that's all there is, and the physician's report, good for them. And I want to be able to help empower them to do that. So I will say it depends on the preference of each circuit and judge. Oftentimes as well, one of these rights that I've even listed here that triggers other problems. I don't know if you guys have had experience with kiddos with intellectual or developmental disabilities going into an inclusive ed program, whether it's one at UCF, UNF, there's one at Clemson, there are a number of them all over the place. And they are great and very important and do great work. And it's critical that these kiddos have shared life experiences like their siblings and peers. Well, that's great. But if you take away their right to make social decisions, number 4, can they do that? Can they go to that program? They cannot. They will actually get rejected from those programs. So we have to be very careful and very thoughtful about that, because most often parents of children with special needs, I will say, are very careful about protecting their child from being taken advantage of or abused or neglected in any sort of way, which is true for all of us. But as a dear friend of mine who used to run the UCF program said, if I sent Emma off to college assuming she'd make good decisions, but knowing that she would very likely screw up a little bit here and there, and gave her that dignity of risk. I have to the extent it's safe for May, do the exact same thing for her. So be thoughtful if you're working with a client who wants to take away the right to make social decisions, because very likely that will create other problems. Okay, next slide. All right, so what does each local circuit require? That's going to be a conversation you all, you know how it changes as different judges come and go. You certainly know different circuits have different rules, and some of them are, very hard and fast about that. So I've made a list of some of the ones that we bump into on a fairly regular basis. I told you about some, but not all. What about ABLE accounts? If you're not familiar with ABLE, that's a whole separate presentation, but ABLE United is an amazing group. And my child has an ABLE account, works well with special needs trusts. But if they, as she turns 18, are we going to have to do a guardian advocacy of the person and property for May if she has an ABLE account? Well, there's arguments made on both sides of that. Some are very like the, I don't have to report, I don't have to have a guardianship of the property if all there are Social Security benefits, because Social Security monitors the use of those funds. And that's true for ABLE as well. That's some of the arguments that we're making. So does the circuit require them to account for assets in a special needs trust? What if the trustee is a corporate trustee? Again, it depends on each judge and each circuit sometimes. How does a local judge treat a non-felonious criminal background for a guardian advocate? It wasn't Judge Takis, but I had another judge out in Lake County who lost his ever-loving mind because the parents had very minor misdemeanors from when they were like 18 in New Jersey, but they hadn't reported it on their questionnaire, and he truly about lost his mind yelling at them. I wasn't sure at first that he was going to even appoint them, and it was seriously like one shoplifting purse bag, like nothing. And they were in their 50s, but they hadn't reported it, so he lost his mind. What about bad credit? How is the judge going to treat that? So those are all issues that can come up, as you all know. But it's sometimes a little more pressing when mom and dad are trying to do it themselves. And what I always remind them is if they think they're going to have an issue, they're far better off to do it with an attorney, so we can make the argument for them and help get them through that process, versus them trying to go it alone on their own. So yes, ma'am. Next slide. So I've just given you a copy of this statute. I will tell you, it will be different than what you're used to in a guardian advocacy. In theory, there is no determination of incapacity, even though it talks about it in the statute. There is literally just that letter from the treating physician. May has Down syndrome. May needs all these things. And so there's no examining committee. They sign off. There is no order determining incapacity. That becomes important because in the next slide, so in the standby guardian, this is just so there's, in a guardian advocacy, there is no adjudication of incapacity. May would never be determined to be incapacitated, right? So, sorry, Julie, now next slide. So that becomes a problem because in the standby guardianship statute, I bet you've never noticed, but it's under the petition, upon the petition of a currently serving guardian, a standby guardian of the person or property of an incapacitated person may be appointed by the court. Well, May's never going to be determined incapacitated if she just goes through guardian advocacy. I will tell you 99.9% of judges just overlook it and will do standby guardians, whether it's another sibling or whoever, an aunt or uncle, but the statute is actually quite clear on that. So one of the things we're working on is getting that revised to allow for this in a guardian advocacy as well. Next one. Okay, so this is just the classic guardianship. This is what you guys know. This is what you walk every single day. I'm going to go really quickly through this part to make sure we have plenty of time for questions. But is a process with two legal proceedings, both incapacity and guardianship. You know about the examining committee. You know about the choices between person and property. And go ahead. I'm just going to go really quickly through this, Julie. Continues for the lifetime of the ward or until their rights are restored by the court. I have a whole slide on this in guardian advocacy because that becomes important because it is a little different. Guardianship, generally, it's for any reason, right? The example I always use, whether it's Alzheimer's or a car accident, that's fine with guardianship. It's just not okay in guardian advocacy, right? It has to be one of those 6 intellectual or developmental disabilities plus the, kind of the catch-all of the intellectual. It can be person or property. The rights can be taken away from any or all rights can be taken away. Everybody has a lawyer, and there is a determination of incapacity, right? In the old days, they had 2 physical file folders, and only after they physically shut the file, yes, Catherine has been determined to be incapacitated, then they would go on to who would be my guardian. So, yes, ma'am. Next slide. So again, I love a chart or a table, obviously, because I think it's super helpful in allowing you to compare apples to apples. So as I have parents think through this and what's the best choice for their kiddo, or whoever's going to be involved in the guardian advocacy, here's the basis. For guardian advocacy, it's an intellectual disability or a developmental disability. Versus guardianship, it's any reason. For the type, it's person and or property, but if it's property, you got to have to have an attorney. Obviously, in a guardianship, everybody gets an attorney. In rights removed, in theory, it's some but not all. In rights removed under a guardianship, it's any or all rights. Attorneys, we already talked about the cost. I mean, we do a lot of these where, or honestly, families can do it themselves, right? If they file right after their child turns 18, they can do it for virtually no cost if they have their child determined to be indigent, right? Or if you have us do it, there's a sliding scale, or you guys know the cost of guardianship can be enormous. The incapacity determination is based just on that letter from the treating physician versus an incapacity in a guardianship is that 3-member examining committee. And then the timing, I mean, I put 30 to 60 days, but honestly, sometimes I've seen it be a couple weeks. And although there's supposed to be a hearing in some counties, the judges just enter the orders. Versus in a guardianship, you guys know this takes us forever to do this. So next slide. All right, well, there's my nugget. So you may not be aware that October is Down Syndrome Awareness Month. You may think of it in terms of other things that are important that are popular to worry about that month. But for us, it is Down Syndrome Awareness Month. And there is a big event in Central Florida called Step Up for Down Syndrome. And there are some bragging rights when you raise money. And so that year, May was dressed up as Rosie the Riveter. So what is the right choice, right? What is the right choice for my family? Well, prior to 18, everyone is presumed incompetent. So I always make fun of my 2 older daughters, particularly my middle, because she felt like even at 16 or 17 that she was completely competent, that she didn't need anybody's help. My joke was as long as she had my credit card, but she was completely competent, but she wasn't, right? In the eyes of the law, she was incompetent until she turned 18. Over 18, everyone is presumed competent until the court rules otherwise. So presume competency. Don't presume that just because you've met May and she has Down syndrome, that she needs a guardianship. Don't presume that she needs this, that, or the other, right? If you've met one person with insert disability, you've met one person. You all know that we have to pick the least restrictive alternative that meets her needs. So how do you work that out? Like, how do you determine what the best choice is? Well, I love the Wings decision-making toolkit. It is tough to work through. It is hard and it is very emotional, but it's a good way for you to think about as a parent, what is the best choice. And then also, I always remind people, I regularly over and underestimate my daughter, well, frankly, all of them, but particularly May, because it's easy to overlook her incredible strengths when you focus on her weaknesses sometimes. So I remind parents to go get those recommendations from your child's treating physician or the other trusted partners in your life that help your child. That includes the teachers or therapists or paraprofessionals. They will have suggestions and feedback. Maybe consider having them fill out the toolkit as well. So if you hit the next slide, I'm going to show you that. And then also, I remind everybody, it's easy to presume that a person who's nonverbal somehow is less than typical people, right? But the answer is Elizabeth Bonker was, sorry, it always breaks me up. She was valedictorian at Rollins 2 years ago and is nonverbal. She has autism and she's nonverbal. And she used her device to make her valedictorian address. So never presume that lack of an ability to communicate or to be nonverbal means they can't still make decisions for themselves and be fully competent. I know you guys walk this walk every day, so I know that's probably not a mistake you would make, but I feel compelled to remind everybody because it's so important to me. Okay, sorry. Now we can go to the Wings toolkit. This is just the cover sheet for it, so you know what you're looking for. You've landed on the right place if you find it. If you'll go to the next slide, and you guys are going to have access to my PowerPoint. It's on my website. I give it far and wide. I know it's hard to read those questions, but it starts with things like, can I express my own choices and preferences? And then the green column is, I can decide without support. The yellow column is, I need support to decide. Or the red column is, I need someone to decide for me. All right, well, can I express my own choices and preferences? I promise you, even at 10, May is very clear about her choices and preferences. Can I ask my family, friends, or circle of support for help? Yep, she will. She will absolutely staff up whoever she can. Then as you go down the list, can I manage my money? Can I apply for benefits if I'm for the benefits that I'm able to receive? Can I make everyday purchases? Can I pay bills on time? Some of these are stuff that, you know, you think about a typical 18-year-old and you're like, I'm not sure, much less somebody who may have an intellectual or developmental disability. So I find this incredibly helpful. And then you go to the next slide. Like, if you think those are hard, now let's go to healthcare management. Can I make decisions about where, when, and what to eat? Yes, May Davy would eat burgers and fries or pasta and sauce all the time, whether that's good for her or not. Now, actually, can I take medicines as directed? She reminds me some evenings that she needs to take one medicine at night. Can I understand the need to maintain personal hygiene and dental care? Well, she'll brush her teeth, but how good a job she's doing is a question mark. But then you scroll down to relationships. Can I understand the need to consent to sex? Like, these are some tough questions, right? And as a family, I make every single client who wants to do a guardian advocacy with me go through these and provide a completed Wings questionnaire before I'll take them on as a client, because I want them to have thought through the hard questions too, as well as the easy questions. And I've really given this a lot of thought, because it's too easy to just be, she can't do this, that, or the other. No, I want you to really thoughtfully consider it on a really careful basis. So, okay, next slide. So what are the next steps? Okay, so that year she was Captain Marvel, if you don't make the leap, but May Davy, Captain Marvel. All right, what are the next steps? Next slide. So determine what's right for your loved one with IDD. If supported or shared decision making is the right choice, that's great. Figure out how to do it for your family. And there's all sorts of options, whether you choose to do it orally or in writing. And I've made sure you have those links and that information. Next slide. What about substituted decision making, right? Powers of attorney, healthcare surrogate. No problem. If that's your choice, great. I strongly encourage people to use highly qualified attorneys who do this all the time. There are a bunch of us who do this. There's a great website. On our website, we have a number of folks who regularly volunteer for a program I provide, aka there are a bunch of attorneys you already know who do great work all over the state, because I count them as friends as well, right? I do this program Low Down on Law, right? Everything I do now seems to have a take on Down syndrome, so it's Low Down on Law. And this is the program I do twice a year to help families work their way through this process and think about this and so many other choices that are now tasked to them as the parent of a child with special needs. So next slide. So what about guardian advocacy? Well, that's great. And then we try to give people lots of options, because not everybody can retain us to do the whole thing for them. So I describe it sort of in the context of homework. Can they do the process themselves using the materials, including the step-by-step guide? Also known as, can you do the homework yourself and then just turn it in? Or do you want to do the homework and then have me look at it before you turn it in to your teacher, aka the clerk, so that you go forward with the case? Or do you want me to do your homework for you that you then turn in, right? Or do you need me to really do the whole thing, right? That's fine. And then, or if you choose guardianship, then making sure they understand they have to have an attorney and understand that whole process. Okay, next. In guardian advocacy, on a practical level, you guys know what this looks like all the time. You got to file the initial pleadings. They got to get their fingerprints done. They have to do their credit check. Notice to other family members is sent, which is sometimes shocking and horrifying to them, whether it's an ex-spouse or whatever. The court appointment of the attorney through usually the Office of Regional Conflict Counsel, at least in Orange and Seminole, and some other counties, to represent the person with IDD. And then sometimes, though there's supposed to be a hearing, again, sometimes there is, sometimes there's not. So next slide. Moving forward with the judge's expectations, you guys may know Judge Weiss, that was in Osceola for years. He's in Orange now, and that was Judge Hudson, who used to be in Volusia before she retired. I have them come and speak at Lowdown, and our next Lowdown is coming up in November, but I have them come both meet the families, to be individuals to the, so that the parents get to meet them, also so that they get to meet the families. And so we just talk about, if you'll go forward with the next slide, the normal things. Oh, and there's Judge Schreiber. The normal things you're used to seeing. Do I really have to go to court? What should I bring with me? Is the judge going to be mean to me? Are they going to take away my loved one? What if my family member is scared? What if May's scared and doesn't want to come to court? I mean, I got to tell you right now, at age 10, like, I can't imagine trying to get her to do that. There's no way. What are some things I should not do? We now, within the era of Zoom hearings, right? We tell them not to be driving in a car, not to be drinking, not to, all the insane things we've seen, and how long will the hearing take, and all those things. So we just try to prep them for the process, because I will tell you, parents are just absolutely terrified. And you guys know this from having done this a long time, but they're terrified of the whole process. They're terrified of doing something wrong. They're terrified, really, about the whole thing. So I really try to give them some peace and some grace, and get them through this process in a way that's both helpful to them and their loved one, but also just so they have a better feel for the, for our legal system as we walk them through this process. So next slide. And then I explained to them that once they get appointed, then their duties transition into Chapter 744, right? With the guardianship class and the annual reportings and all those things. All right, next slide. So we talk about, and then ultimately, can you change your mind in the future? All right. So maybe I'm guardian advocate for May for a long time, but then either I get too old, or I just don't want to do it anymore. And so I need someone else to take over. So I explained that any job a person in a black robe is given you is yours until the person in the black robe says it's not your job anymore. So you can't just quit, but there's a process. And the other reality is, absolutely, especially I think more so in guardian advocacy, sometimes even than in guardianship, is, the person can grow and develop. A person with Down syndrome or autism may be chronologically a given age, but they may not be developmentally that age. I know for my child, she runs about 3 years developmentally behind her chronological age. So at 18, she may absolutely not be ready for this, but at 21, it may be time to start fading some things back to her. And I had a terrific case, which is my favorite one forever, where the young man was in actually a plenary guardianship. I never quite understood why. And his family came to me and said he had fallen in love, and it was a young woman with special needs as well. And both families were very supportive, and both felt that their children were capable of making these decisions and being a married couple. So we filed, as you know, a suggestion of capacity would be what you'd file in a guardianship. In guardian advocacy, it's a suggestion of restoration of rights. The doctor met with the young man, he was 25 at that point, and his right to marry was restored to him, and they did in fact get married. So I love it. So on the bad days when things are hard, that's one of the ones I think about. So do you have to be guardian advocate forever? Nope, I just talked about that. But again, I have to make sure I've got a succession plan. And so that's why I'll have a standby guardian behind me, whether it's one of my kids or whatever. So next. And here's some resources. So in case you guys have more questions, or just like, wow, I need to know more, this is great. Okay, so Miss Julie, do you want to pop up some questions, and we will try to spend the rest of our time, our 9 minutes or whatever it is we have, to answer some questions.
Sure, we have a couple in the chat, and then if you guys want to put more in the chat, or if you want to come off of mute in a few minutes and ask some questions, that's great. So Robin says that she has a client with an intellectual disability. She lived with her family until the family died, and she is 60. She grew up in Maryland and West Virginia and is on SSDI. She
Okay.
starts benefits January before she was 18 years old. How can she get information to prove all of this to APD? Like, I guess to
Uh,
prove the intellectual disability.
Okay, so I am not an expert on APD, but the good news is I have one who is. And I describe him, he's a dear friend of mine who used to be with APD until he retired. I describe him as Mr. Incredible from The Incredibles, if you recall the movie. So, and if you don't, I'll tell you because it's funny and it makes me laugh. So in the beginning of the movie, Mr. Incredible's working for the insurance company, and somehow magically his clients are all getting their insurance claims paid, whereas no one else is, and he gets berated for that. Well, that's the great thing about Reed is he knows the APD system better than God. So I don't know his phone number. Actually, you know what? That's the benefit of me being in the car with my phone in my hand.
I'll
I can
capture it in the chat for you.
Okay, so his name is Reed Stephan, Stephan, and his phone number is 407 768. Wait, let me give you the other one 407 256 0076. And Reed will tell you exactly what you need to know. And if you struggle at all to get in touch with him, let me know, and I'm happy to connect. I don't have his email address in my phone, but he will be the one who knows all things about how to get this done with APD. He is amazing. He's so amazing that the Down Syndrome Association has him on a retainer to help all their families.
Oh, wow.
Yeah, it's a godsend.
Well,
So,
I dropped that number and that name in the chat for everyone. So if you guys want to grab it out of there, it's sitting in there for you. And I'll also ask Kate to send it when she sends the presentation and the certificates. I'll ask her to send that information too.
and we all know that APD has their 25-year wait list and all these things, but don't give up. There are ways to get around some of that stuff by moving yourself through the crisis list. And they are also horribly sloppy and lazy. I will tell you, I applied as every parent of a child with special needs is told to do. After age 3, apply to get your kiddo on the wait list for med waiver. I sent mine in. I'm a lawyer. I sent it in by certified mail, return receipt requested. I said, hey, Reed, would you mind just checking to see how May's application's going? I never heard from anybody. They never got it, except for I have the green card with someone's signature on it. Well, it turns out the mailman would just sign off on their stuff and because of whatever, and just they never got it. So you guys know those tips and tricks, but it happens to all of us. So, all right, next up, Miss Julie.
So the next question we have is from Teresa. She said, if the young adult keeps their social rights, how do you deal with the risk of the online bad guys and social media?
It's a balance you got to blend, right? That's the, it depends on what's most important to you. Like in all cases, if your concern is your kiddo is going to be online doing dangerous, I mean, okay, let's be honest. Even if you took the right to make social decisions away, how is that going to help you turn off Snapchat or Instagram? Like, no, Snapchat and Instagram don't care about a court order you have from, Lake County, Florida. So that's a whole different level of control where you're back to almost normal levels of parenting and making sure your kid's safe, where they don't have access to Snapchat and Instagram, but we're learning all the time, right? Now they can connect with people in Roblox and all sorts of places. So sorry, that guardianship's not going to help with that one, nor is social decisions. Because I had a case where the the young man was at UCF and the grandmother was completely obsessed with controlling every aspect of his life, and they threw him out. Because, I mean, not unreasonably, he was on the spectrum and would make bad decisions with people online, but that's not their job. They're not set up for that.
Right.
So
That was really our 2 questions in the chat. If you guys have more questions, we have a few more minutes. You can come off of mute. You can ask your question. If you don't have the tech to come off of mute, you could drop it in the chat. We're also getting a lot of people that are just saying thank you and thanks for the presentation. They really enjoyed it. Teresa, did you have a question? You're waving your fingers.
I do. I think, Kathy, if you will go over just a little bit, a lot of the guardians on this group are relatively new. And
okay.
they've probably either not been asked or not considered being involved in a guardian advocacy. So we're not talking about family cases so much.
Okay.
Why don't you talk a little bit about the good and bad of a professional guardian accepting a guardian advocacy case over with the same person, let's say, over a 744? What's, from a professional guardian point of view, not the family member, what's the good and bad to that?
I mean, you're going to get a different character, right? So it depends on what you're comfortable with. If you like dealing with old people with Alzheimer's, you're not getting an old person with Alzheimer's. If you like to deal with people in comas that are super easy, this ain't it. You know, if you're taking on a young man with autism who, calls in bomb threats to the police department, you have to understand what the behaviors are and what the issues are. And just like you're going to have to understand government benefits, but it's, to me, it's on an exponential level, right? Now you've got APD in play. Now you've got not only SSI, but SSDI. And what about DAC benefits? And it's so much more benefit driven, and it's so much more, you know, how to keep them safe. It's not just an adult in a nursing home and I've had 5 nursing home rape baby cases. I understand how complicated it is to keep people safe. I get that. But I got to tell you that when I found out I was pregnant with a child with Down syndrome, having had so many nursing home rape baby cases and violence against people in nursing homes, the only thought I had was, how will I keep this child safe? How will I keep this child safe?
Right.
So
and that's you're saying is, I think, why most professional guardians will say no to guardian advocacy cases. And one of my goals in the peer group is to get them not as afraid. And one way is, when they do a guardian advocacy, to not let go of guardian of the property, even if it could be because they need an attorney representing them the entire time. As a professional guardian, that's kind of what when we're talking about it, I'm like, it's not that you shouldn't take these cases. It's, if you do, don't do just guardian of the person for a guardian advocacy. You need to keep counsel. That's more what I'm worried about them doing.
Yeah, well, that's right. And that's a very reasonable concern, especially if they don't have, it's a huge wealth of knowledge and experience. Right. That's what essentially you're buying from us.
Right. And getting them to get many of the new professional guardians just don't even want to touch APD, and they don't want to go down this whole road. But we need more of them because, every day we get calls from facilities that someone's about to turn 18 and they've been in the foster system or APD system and there is nobody. So yeah. I'm trying to make it, one of the reasons for having you speak is so they won't feel as scared about everything out there, and that there are solutions and resources. But that's the piece that I think is the problem. Everybody wants to have a guardian advocacy that's only guardian of the person. And I think with a professional guardian, that's not normally a good idea.
Yeah, no, I definitely wouldn't do it that way, especially when it's a non-family member, because just there's so many other pieces you're going to have to know and manage and just sort of comprehend. Yeah. And it's sort of like when baby lawyers call me and say, hey, man, can I get your form for a special needs trust? I'm like, no. Yeah, but do you have any idea how complicated this is and the 400 levels of details I get to? I got in an argument last week with, an attorney, a PI attorney, who was like, oh, you don't need, I'm doing a special needs trust for this person because I talked to the structure broker. And I said, right, but is she disabled? Well, no, but she has kids with disabilities. I said, no, the benchmark question in a special needs trust is the person disabled? If the answer is no, you can't do this. You can't just play with this stuff. But there are a whole lot of us who know this and love this and walk this every single day, that if you get in and you're like, I can't figure out how to manipulate the iBudget or the med waiver program, there are absolutely experts who do this all the time. Just lean on them. It costs money, but understand, I'm telling every single parent that, if they have no one, if there's no one out there, we're going to have to find professionals to do this work. And that does cost money. So, but good work costs money. So.
And to that point, I noticed your last slide, Catherine, was your contact info. So I dropped your contact info in the chat for everybody. We will also send out the slides, but if you're wondering how to reach her, how to get a hold of her, her phone number is down there in the group, in the chat for y'all.
Yes. And honestly, anybody with an intellectual or developmental disability, like, I love a classic guardianship as well. We have a couple hundred of them, but really, if a person has IDD, you've got my heart, especially Down syndrome. So, and I know that world very, very well, and, am honored to help many families with loved ones with intellectual and developmental disabilities. I feel like that really is my purpose in life. So.
That was May's gift to you. That is May's gift to you.
It is indeed. It is. So, all right, guys, with that, if you guys have other questions, please don't hesitate for a moment to reach out. I would be delighted to assist. And with that, I will head my way toward my nugget who is falling apart because her big sisters are going off to college and she's going to be stuck with mom.
Oh, no.
Well, go take care of her, and thank you very much, Catherine. We'll keep the the Zoom open for a minute if you guys want to sit and chat. But thank you again, Catherine. It was a wonderful presentation. We appreciate it.
Thank you, guys. Have a great day.
You too.
Bye, Catherine.
Bye-bye.
I'm gonna pause the recording, everybody. But if you want